Hey, beautiful people, welcome back. So, on YouTube, we spoke about the title of nobilities and how all attorneys have a title of nobility. And in order for you to be able to go at them properly, you have to have your own title of nobility so that you can speak on an even ground or a superior ground. In addition to that, that's not put on YouTube, that is here on Patreon, is this: all lawyers are attorneys, and they are wearing two hats. That is the only reason why that attorney against you, or the attorney that they're trying to put on you, can speak to that judge in a private chamber or outside the record, go to lunch with them behind closed doors, talk to them on the phone behind closed doors about the matters, and be able to really go through the back door behind the principles of due process and ex parte hearings, which is unconstitutional. That is how. Now, the way that you counteract that, remember, they both have title nobilities. And in the front end, that judge is playing the position of the public trust or public office, which is mentioned here in Clause 8, Article 1, Section 9. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them. The United States is not the one granting them that. The United States can only grant titles based on the Congress, which makes law. So the congressional records is when it's going to mandate title of nobility to that judge or that attorney. But this specific law is telling you, the United States shall not do it. But those title of nobility of esquire that all judges have as attorneys is not granted by the United States. It's granted by the British Accreditation Registry. To accredit something is to give credit, to vouch for something, aka to grant them. By whom? British. That foreign entity, the United Kingdom, that has colonies here doing business. In other words, British Accreditation Registry, and they are members of it. Do you see how this ties in now? So they have a workaround this, because this limits the United States, but does not limit the British and its accreditation system, which is foreign to the United States. But wait, it says here that Congress shall not consent or accept any present or title of any kind, whatever, from a king or foreign state. But that mandate is limited to the Congress and the fact that they can't do it. And this is how and why all judges are acting in their private capacity. This is how they're functioning in their private capacity outside the Congress. So this binds the Congress to not make any law to grant them title of nobility. But it doesn't bar private man. And that is the reason why they can do whatever you want with them. And the only way that you can step to them, aka privately, because they are functioning privately, the way you can step to them privately is through your title of nobility, because that title of nobility is what shows your standing and capacity, and that title of nobility is tied to your bloodline. So this is where, when you hear Morris talk about the title El, Bey, Al, and Ali, although 70-80% of them don't know this, don't know how this relates to what's going on, they hear it or read it somewhere and they just go with it. So on that end, when they speak about the titles, loosely they're correct, but the specificity of how it applies and why, they don't get it. I have come across a lot of supposed Moors who have all this title but are still doing a lot of secure party stuff, a lot of man in the land stuff, and they're still dealing with a lot of issues in court. And I'm thinking, well, you're Moor, you should not be going through this. But they are, because they don't know this foundational principle. Here it is. They are functioning privately, the judges and the attorneys, because this binds the Congress. There are laws governing the British accreditation system that's passed by the Congress of Great Britain. This ties the legislative department of their colony and binds them and denies them the power, hence power is denied to Congress. But they can still make those laws outside and then come in privately. Remember, the position that they play is that of a public one. Hence, the position of trust and office of profit being compensated by the sweat of the equity of the people, based on the position of trust that the people put on them to be able to keep society in order. But then there's another flip side to that, which is the private interest that they have from foreign powers. This is regarding the public interest that they're denied to. That is the reason why the people who ratified this knew that there are other loopholes. And because of those other loopholes that they knew existed, they created the Bill of Rights, which gives you the private right of action. The only ones that can truly enforce this private right of action are the ones with true title of nobility. Anyone else can loosely enforce it. But if you don't have a title of nobility, you cannot come in as the capacity of a king. You cannot come in privately. To come in privately is to come in as the capacity of a king. The title El, which is referring to the Phoenician, Mesopotamian god, which is a title. Bey, the one who enforces the law. Ali, which is a supreme title. Day and Al are titles referring to people with knowledge of astronomy and things like that, and basics of other aspects of social things within the everyday activity. If you don't come in with one of those titles, specifically the El or Bey, you will not be listened to. And if you are listened to, they would only do it partially. That is how you truly are able to put this to use. Because this Article 1, Section 9, Clause 8 limits them on a public level, but they are in fact coming in privately, because all those courtrooms are office spaces that are bought privately and rented out privately by the attorney law firms owned by the judges, and they speak to themselves privately. The way you are able to access the private chambers is by coming in privately. And if an attorney is involved in the equation that you're trying to cut them out, and they are holding the adopted title of nobility called Esquire, then you can't speak to them on an even level and compel performance. A king cannot or is not mandated to listen to the demands of his subject. You come in as the capacity of a king of this land, and you speak to them because you have a superior claim, because you are the ones that they came to, considering you know who you truly are and you're not pretending. You are the one who they came to do commerce here by way of the treaties, by way of the House resolution that's been shown on YouTube that connects the foundation of the United States Constitution and the true Republic's Constitution for United States of America that everyone goes about looking for the specific verbiage, but in truth it's the functionality and the substance of it, which is the Articles of Confederation. You are the one that gave them the power to create all those, and so you are the only one that can check them, because you are the only one that holds a mantle of sovereignty to enforce that checks and balance. And the only way you can do that is coming through your title of nobility. And that title of nobility grants you access to the private part of the court, because they have private aspect of the court beyond what people see for face value, which is the public. That private aspect of the title of nobility that they hold from Great Britain, which is Esquire, which goes back to shield of who? The queen, or the prince. This is regarding their public capacity. The private capacity is based on your title of nobility and being able to step to them and speak properly. This is the part that's not explained in details on YouTube. Are we going to go more into this? Yeah, we are. But put that into consideration. Best of luck.